This video is for educational purposes only and does not constitute legal advice. Consult a licensed attorney regarding your specific situation. The radio interview depicted is a reconstruction for educational purposes and is not real. Some content in this video was created with the assistance of AI.
Good morning, California, and welcome to Legal Matters. I'm your host, Sarah. Today we're talking about an issue that many people have heard of but may not fully understand: medical negligence. To help us walk through what that means in California, we're joined by Professor James Whitfield, an expert in tort law. Professor, thank you for being with us.
Thank you, Sarah. It's a pleasure to join you this morning.
Let's begin with the basics. What exactly is medical negligence?
Medical negligence is really just negligence that happens in a medical or professional setting. In California, it's still considered negligence under the law, but we use the word medical or professional to reflect that it involves doctors, nurses, hospitals, or other healthcare providers. It simply means that a provider did not act with the same level of care and skill that reasonably careful professionals in their same field would have used under similar circumstances.
So if someone wants to bring a claim, what exactly do they have to prove?
There are four essential parts. First, the provider had a duty. That means they were required to use the level of skill, prudence, and diligence that other professionals in their field ordinarily exercise. Second, there must be a breach of that duty, which means a provider did not meet that expected standard. Third, there has to be a connection between that breach and the patient's injury. In other words, the negligence must be a cause of the harm. And finally, the patient must have actually suffered damages, such as physical injury, financial loss, or emotional harm as a result. If any one of those parts is missing, the case cannot succeed.
You mentioned the standard of care. What does that mean for general medical professionals?
For non-specialists, like a general physician, surgeon, or dentist, the standard of care is the level of skill, knowledge, and care that reasonably careful members of the same profession would use under similar circumstances. It doesn't mean perfection. It means acting as a reasonably careful doctor would. And in most cases, the standard of care has to be explained to the jury by expert witnesses.
And what if the provider is a specialist?
Then the standard of care rises to match their specialty. For example, a cardiologist is measured against what other cardiologists would have done in similar circumstances. The duty is not about being extra careful. It's about having and using the special skill and knowledge that comes with that area of practice.
Let's talk specifically about nurses. Are they held to the same rules?
Yes, but with an important distinction. A nurse, whether a registered nurse, vocational nurse, or nurse practitioner, is measured against what other reasonably careful nurses in the same role would have done under similar circumstances. Courts have been clear, you don't judge a nurse's conduct by a physician's standard of care. Nurses have their own professional standards, which are strict but tailored to their training and responsibilities. And as with doctors, juries usually need expert testimony to understand what that standard is, unless the negligence is obvious to anyone.
Does the law expect doctors and nurses to always get it right?
No, not at all. The law recognizes that even good professionals can make reasonable mistakes. A provider is not negligent just because a treatment wasn't successful or an error happened that a reasonably careful practitioner might also have made. Negligence only exists if the provider failed to act with the skill, knowledge, and care that their peers would have used in similar circumstances. The law does not require perfection or guaranteed cures.
What about situations where a general doctor should have sent the patient to a specialist?
Good question. If a reasonably careful doctor would have referred the patient to a specialist but failed to do so, that can be negligence. However, if the doctor treated the patient with the same skill and care as a specialist would have, then they're not negligent. The same principle can apply to nurses. If they should have consulted the attending physician but didn't, that may fall below the nursing standard of care.
Let's circle back to causation. How does the law decide if negligence actually caused the harm?
The patient has to show it's more likely than not that the negligence caused the injury. That's what the law calls a reasonable medical probability. It's not enough to suggest it was possible, it must be probable. and expert testimony is usually required to prove that.
But there are times when no expert is needed, right?
Correct. That's the common knowledge exception. If something is so obvious, for example, leaving a sponge inside a patient, jurors don't need experts to tell them negligence occurred.
California also has something called MICRA, the Medical Injury Compensation Reform Act. How does that affect these cases?
MICRA doesn't change the 4 elements, but it does shape outcomes. It limits non-economic damages like pain and suffering, allows some damages to be paid over time, and affects how insurance payments are handled in court.
Can a doctor or nurse just stop treating a patient?
No, not without proper notice. Abandonment happens when a provider withdraws care without giving the patient enough time to find another practitioner. That's considered negligence unless the patient agreed to the withdrawal or refused further care.
I've also heard about something called the captain of the ship doctrine. What is that?
That's about surgeons being responsible for negligence by others under their supervision and the operating room. Traditionally, a surgeon could be held liable for the mistakes of nurses or staff working under their direct control during surgery. Now, some courts have narrowed that rule, but the underlying idea remains. A patient on the operating table reasonably expects the surgeon to oversee their care.
Before we wrap up, can you explain again the difference between professional negligence and ordinary negligence?
Ordinary negligence happens in daily life, like a driver running a stop sign. Professional negligence occurs in the course of professional services. The law still measures conduct against what a reasonably careful person would do, but in professional cases, it's judged against what a competent member of that profession would do under the same circumstances.
Professor Whitfield, thank you for such a thorough and clear explanation. I think our listeners now understand that medical negligence is a broad subject covering not just doctors, but nurses, specialists, and even the responsibilities of surgeons in the operating room.
Thank you, Sarah. It was a pleasure to be here.
And thank you to our audience for tuning in to Legal Matters. Remember, medical negligence cases can be complex, and professional advice is always important. That's all for today. Have a great morning, California.